So we're going to move quickly to our next speaker, in part because he literally has a plane to catch. You know, sometimes when we talk about errors in the criminal justice system and we talk about people who are wrongfully accused or wrongfully convicted, we talk about people like John Thompson, who was a 22-year-old high school dropout living in the New Orleans housing projects. Sometimes we talk about people like Keith Harward, who we had here earlier in the spring, who was a seaman on a U.S. Navy ship in a port at a time when a rape was perpetrated. Sometimes we talk about the owner of a billion-dollar medical device company, and the point is that the errors that we have in the criminal justice system span all races, colors, creeds, socioeconomic classes, and levels, and it's important to keep that in mind. The first-person narratives of the experiences that people go through are vitally important in understanding how the criminal justice system works, and in understanding that as much as we talk about the system, that system is made up of individuals, and it's the choices that individuals make and the suffering that individuals suffer in this system that is so important for us to pay attention to and respond to as we make the criminal justice system better. And it's in that context that we're absolutely thrilled to have Howard Root here to tell his story today. Howard was the CEO, founded the medical device company Vascular Solutions, a cardiovascular medical device company, in 1997, and spent 20 years building this company. During that time, it invented or launched over 100 medical devices to help improve people's lives and save their lives, and it created more than 650 jobs. Due to an accusation by a disgruntled former employee, a federal investigation into the sales and business practices of Vascular Solutions was launched. And it ultimately led to a 5-year, $25 million false prosecution with 121 defense attorneys. Do I have that right? Right. After a 5-week trial, Vascular Solutions and Howard were found not guilty on all charges. And he's written about that experience in a book called Cardiac Arrest, 5 Heart-Stopping Years as a CEO on the Federal Hit List. And he's here to tell you his story now. So please welcome Howard Root.
Thanks, John. And thanks to the Quattrone Center for inviting me out. I'll try to pull up my slides here if I can do the technical. Let's see. Go to controls. I think so. There we go. Look at that. Medical device guy can run technology. What a great idea. So thanks for inviting me out, and thanks for allowing me to talk about my case. And I was thinking before, when I was preparing this, I was thinking there's a kind of a cautionary tone with this audience, because this audience is probably the most educated criminal defense audience I've ever spoken to about my case. And I know when I look at things like this with my experience, I quickly jump into the structural issues in criminal justice. And I think you will all pretty much do the same thing. You can look at my case and you can start thinking about the Brady Rule and open file disclosure and how that would improve the system, how the grand jury has gone from a tool to protect innocent defendants to a tool used by prosecutors to manufacture evidence. And then Frank Quattrone's and my own personal subject, favorite subject, absolute prosecutorial immunity, and Bivens' actions and the limits in the Hyde Amendment and how unjust those are. But if you focus on that, you will miss what I think is the most important issue in my case and about anyone's case, and that's the culture of the American prosecutorial system. The culture of prosecutors, the culture of judges, the culture of investigators. And if you miss that, you will miss the single most important thing that I think we need to change. Now, just like if you're going to see a culture of a country, you can't be a tourist. You're not going to pick it up. You have to be a worker. I think the way to see the culture of the American prosecutorial system is to get involved in the system as a defendant to see how it happens to people like me, or it happens to Frank, or it happens to a guy in the inner city accused of a false crime. Because it's remarkably similar what's happening to these defendants across America today. So with that, let me tell you the history of my cardiac arrest. So I'll give you my background. I was born in the 1960s in Minneapolis, where I do think I was a pretty cute little kid. 1970s, we moved to a suburban high school, which you can see from the photo. That is 100% 1970s suburban high school. 1980s, I went to the University of Minnesota, both for college and for law school, where I have to confess I did commit a crime, because in Minnesota, that is felony hockey hair right there. I got out of law school in 1985, and I wanted a job as a corporate lawyer. I wanted to stay in Minneapolis, so I took a job, and you know what I had to do? I had to sell out, I cut the hair, and I looked pretty darn presentable at that point in time. After 5 years of that, I wanted to move into the business world. I wanted to do something where I was working with the people rather than billing the hours toward the people. So I took a job with the first client that offered me a job to be general counsel of a small cardiovascular medical device company in Minneapolis. And for the next 6 years, I was in the corporate world, learning everything I could about medical devices, how they're invented, how they're developed, how they're regulated, how they're sold, how they're marketed, until in 1997, I thought I had all the tools to be a successful medical device entrepreneur. And that's when I started my company, Vascular Solutions. And I had positively everything that it took to be a successful entrepreneur, except two little details. I had no medical device and I had no money. But other than that, I was 100% covered. Well, to find a medical device, I found a doctor out in California who had an idea to seal the puncture site in the femoral artery in the groin that's used to implant a stent in the coronary artery. We ultimately called it the Duet because it had two components. We added a second T because that's the German spelling, and we named it at a German beer hall after our first successful procedures when we were drunk. That was a great name. For the money, I went out and raised $1.5 million from this kind of angel community we have in the Twin Cities, and that was in January 1997, and I hired a couple of people I knew. We got together in a warehouse, and we kicked off Vascular Solutions to take that idea and make it into a medical device. I'll track the next 15 years by tracking our stock price against the years. So starting in 1997 with 1.5 million in seed capital, that only allowed us to get started to get it developed. By 1999, we had raised $24 million in venture capital in order for us to take that product through the clinical testing to get it on the market in the US and to sell it in international markets. In 2000, we received that FDA clearance, and now we had to go out and sell it. I had to have a direct sales force. So we raised $48 million in our IPO to create a US sales force and launch this product worldwide. In the first 6 months as a public company, we had a stock market bubble. The stock price went up. We were doing well. Our stock price peaked at $26 per share. And right then, one of the largest competitors, named of St. Jude Medical, local company to the Twin Cities, came out with a competitive product that quickly took 85% share of my market. I was locked at selling $12 million in sales, losing $15 million a year, and that was not going to work. So I went to the board and I said, we got to change our strategy, de-emphasize the single product, develop multiple products. What they are, we'll figure out later, keep our money together and try to turn this ship around. We communicated that to the street. The street took our stock price down 70 cents, not by 70 cents, but to 70 cents. We kept the core group of people together and we head off with our heads down to avoid the bullets flying over us as a public company to reinvent ourselves. By 2004, we had launched 3 new medical devices that we generated internally and developed ourselves. That bounded our stock price up to $6. Over the next 3 years, we launched at least 5 new products each year, continuing to grow sales. Wall Street didn't care because we were a small, unprofitable medical device company. Until one day, we launched the most insignificant product I've ever launched. CNBC Powerline picked it up. Joe Kernan at noon is talking about my little company, and that day our stock price more than doubled and 15 million shares traded. Impressive, since we only had 12 million shares outstanding. But because it was such an insignificant product, over the next 3 years, when results came in, we had a CNBC hangover, the stock price went back down. But by 2011, we had our 10th consecutive year of growth. We were approaching 100 million in sales. We were profitable, and I thought, this is what I wanted to do. Now I've got a good 10 to 20 more years of running a medical device company successfully for everyone's benefit. And that is when my cardiac arrest hit. I was in the airport in Minneapolis, flying out to Boston to talk to investors right before the 4th of July weekend in 2011, doing exactly what I do when my wife is not with me at the airport, going to get an ice cream cone at Ben & Jerry's, not worrying about a little bit of a weight gain. I get a phone call from an employee at the office, and he says, Howard, we just got a subpoena, this subpoena. I said, okay, we got a subpoena. We get subpoenas every once in a while, collection action, an employee, a competitor, whatever. What's so weird about that? I said, no, Howard. This subpoena is from the United States of America, from the federal government down in San Antonio. I said, well, that's kind of weird, but maybe some doctor's gotten involved in something. Maybe they're going after someone, want our records. That's what they're doing. I said, no, Howard. They're going after us. This is a subpoena about Vascular Solutions as the target, and this is a federal healthcare offense subpoena. This is a criminal subpoena. That was the first word I got about this event. Well, I decided still to fly out to Boston. I did my meeting, and I came back. And that weekend, over the 4th of July, I went and started to think about what this all was about. You see, at the time, we had launched over 50 medical devices, starting with the Duet in 2000, 3 new products in 2003, and about 45 more products over the next 5 years. This subpoena was solely about one product called the Veralaze product, which is used to treat varicose veins in the leg. Now, there are a lot of different versions of Veralaze because there are a lot of different veins to be treated. Veralaze products go from 100 centimeters, which would treat the entire length of the leg, down to 5 centimeters, which would treat a very short segment of varicose vein. This subpoena was solely around one type of Veralaze product, the 10 centimeter version that we called the short kit. Now, there are all kinds of different veins that are treated in the leg for varicose veins. Most commonly, it's the great saphenous vein, which runs all the way down the leg. But oftentimes, it's the short saphenous vein, which is in the calf, and as you can imagine, is a shorter segment. There are sometimes ones higher up in the groin, and there's some on the anterior side as well. This subpoena, though, was solely around one group of veins that were treated with our Veralaze product called perforator veins, very short segments in the thigh and down toward the knee. Now, we had FDA clearance for it. We weren't selling a product without getting FDA approval. No one would do that. Our first clearance for Veralaze from the FDA came in 2003, and we had added 7 additional clearances from the FDA for this product line. All of the products we sold in Veralaze were approved by the FDA 8 different times. Well, why do we get so many approvals, so many multiple approvals for the same line of product? Well, if you're not familiar with medical devices, the FDA doesn't approve a medical device. The FDA approves a medical device for an intended use. So a specific use is what is approved. And the legal requirement in the law is that the intended use, when you get the approval, must provide a general description of the disease the device will treat. In this case, varicose veins. Well, one approval would cover all varicose veins, so why do we have 8 approvals for one product? Well, beyond what the law requires, FDA has their own guidance, non-binding guidance, non-binding on the FDA and on the companies. And this is a flow chart they put out to medical device companies like Vascular Solutions, talking about any changes you want to make to the labeling for a medical device. And the flow chart says this: if you're going to make a change that affects the indications for use in any way, any change at all, the FDA wants you to do a new FDA filing. And even though it's not required, in medical device land, we learn very quickly. If the FDA says they want something, we say, yes, sir, and that's what we do, even if it's not legally required. And that's how you stay on the good side of your regulatory agency. And that's why in 20 years of running Vascular Solutions, we never had so much as a warning letter from the FDA. Well, the FDA cleared indications for use for the Veralaze were this. Veralaze is indicated for the treatment of varicose veins, which is the general indication, and varicosity is associated with superficial reflux of the great saphenous vein, a more specific indication, and for the treatment of incontinence and reflux of superficial veins in the lower extremity, even more specific. But even with that, you can't get approval for everything a doctor can use and every specific vein that you can treat. So there were some additional ones that we wanted to add to our FDA filing. And we did that in 2007 when we filed another application, our 9th on Veralaze, where we wanted to clarify the indications for use through the incorporation of short saphenous veins and perforator veins and tributary veins. But unlike the first 8 approvals that came right through the FDA, in this case, the FDA denied our application and said we needed to have clinical data to support this 1/9 application. Well, we looked at doing that. We did some work. We never really got the clinical data, so we never followed through with that. And instead, we told our sales reps specifically what the FDA wanted us to tell them. Now, the doctor can use any device for any purpose at all, but the sales reps are supposed to stick to the specific indications that it's approved for. So we told them in a written document, do not indicate that the short kit is approved to treat perforator veins. The short kit is not specifically approved for treating perforators, taking the most conservative approach you could possibly take. And I know my sales reps followed that because when I looked into this, our sales from 2007 through 2011, the 5 years we had the short kit on the market, totaled up to be $534,000, and sales of our other products in the same years were $474 million, represented like this on the chart, which means that the short kit made up 0.1% of our sales, and 2/3 of my sales reps sold perfectly 0 short kits. Now, by listening to me so far, you can understand that if I told our sales reps to sell something and 2/3 did not sell it, those 2/3 would have been replaced in the next year or two. So this was no conspiracy to sell a product for perforator veins. In fact, it was the exact opposite. And oh, by the way, this product never had any allegation of patient harm, anywhere, anyhow. Well, why did this become a problem? Here's the but, and there's always a but in these cases. I found out by looking at that subpoena that I had 2 out of my 100 sales reps who had gone rogue. Danny McKiff was our Utah sales rep, and Kip Thino was his manager out for the western region of our country. We had 8 different regions. And each region got together twice a year to have a regional meeting with about 10 sales reps and the manager, and then to get together in a regional hotel, and they'd talk about issues. This one was in the Holiday Inn in Burbank, California. Now, I submit to you, nothing good has ever happened in a Holiday Inn in Burbank, California. And nothing good happened this day. You see, Danny used to work in a vein clinic where his father, who is a physician, was treating perforator veins with other companies' laser products. And Kip knew that. So Kip said, Danny, get up and talk about what your father does in his vein practice. And Danny did that and gave out 2 documents. One called Tips for Treating Perforator Veins, the other one, Treating Perforator Veins, ! An easier way. 2 clinical documents, just clinical information, nothing that went through the home office, nothing that I'd ever seen before, nothing that approved against my instructions to not talk about perforator veins, but 2 documents given out to 7 sales reps in a Holiday Inn in Burbank, California. And that was what the government thought was a nationwide conspiracy by me in order to promote a product off-label. Well, now there's an obvious question in your mind. What are the federal agents doing hanging out in a Holiday Inn in Burbank, California? Well, they weren't there. The way they got the documents is the way they always get the documents. It's through a disgruntled former employee or a whistleblower. In this case, DeSal Bowie was our sales rep in Phoenix. He applied to be promoted to a manager, didn't get the promotion, he quit, and then he started competing with the company. I sent him a letter, he went to a lawyer, and the lawyer said, you know, DeSal, if you've got anything on this company, we can make some money. You see, if you use this qui tam lawsuit provision and you put together a big enough complaint and give it to the government, and the government bites on that, they will give you 25% of whatever they recover. And here's the beauty is, you don't have to pay for any lawyers because the lawyers are the government's lawyers. All you have to do is make out a very large claim so your 25% becomes worth something. DeSal Bowie, who is financially destitute, going through a divorce, actually suicidal at the time, complied. And he came up with an action to recover treble damages and civil penalties on behalf of the U.S. And over a product that made up $500,000 of total sales, he made up a $20 million claim of damages, and the prosecutors bid it. Well, so why do I know that he went after the financial motivation behind a whistleblower? Because there are some whistleblowers in America that do good things. There are other whistleblowers, though, that do it solely for the money. Well, an interesting email I got, or voicemail I got, from Eddie Pedregron, another one of our sales reps, who was also disgruntled when he left the company. And he said to our lawyer, he left a voicemail for our lawyer while this case was pending, and said this: I'm a former employee of Vascular Solutions and have been called in the case against Howard Root in the FDA. I was used in this case to get the indictment, and it was based off of whistleblowers' accusations in order to get financial gain from the company. Please give me a call. I want to help your client. Now, this is a guy who corroborated the story of the whistleblower at the beginning, now wanting to turn over the other way, telling that to the prosecutors and completely ignored. Well, that's all about civil actions. So why was it a criminal subpoena that I got when I first got notice of this investigation? Well, I didn't know it at the time, but I knew it when I read the Yates memo, exactly what happened. You see, Sally Yates, before she left the Department of Justice, put out how they approach criminal prosecutions and civil qui tam actions against corporations. And in it they say, if civil attorneys believe that an individual identified in the course of their corporate investigation should be subject to a criminal inquiry, that matter should promptly be referred to criminal prosecutors. And that's exactly what happened. You see, DeSal Bowie took his complaint to the San Antonio U.S. Attorney's Office. The civil lawyers got it. They looked at it. They gave it across the hallway to the criminal prosecutors, and the criminal prosecutors bought off on this, and they were the ones who led the charge from the very beginning without even talking to me. Well, when I realized what it was all about, I did exactly what every CEO has to do. You send out a litigation hold memo, or your general counsel does this. And the litigation hold memo tells everyone to hold the documents so we don't get in trouble with obstruction of justice. And what I said in here was, this memo instructs you to preserve all documents that concern the use of Verilai's products for the treatment of perforator veins. And every employee got it, including Danny McGiff. And when Danny got that litigation hold memo, he knew that he was in trouble because he had created those 2 documents and handed them out against my instructions. And he thought, I just don't want to get in trouble, I need this job. So he did what a lot of people do when they get in trouble. He tried to correct it himself, and he destroyed the documents from his computer. And we got the computer, and we found out that he destroyed it, and we asked him about it, and then he compounded his error by lying about it to our lawyer 5 times. And the 6th time, he admitted that he had given out those documents, and then he destroyed it. And at that point, I had no choice but to fire Danny McGiff, and he became a former sales rep. I also had to explain that to the U.S. attorneys investigating the case and give them the evidence of what Danny McGiff had destroyed. Now, keep in mind, the prosecutors already had this evidence. It was in the subpoena that was sent to me. This wasn't obstruction of justice in any way. Danny made a mistake. It didn't hurt the investigations. We gave the documents to them. They already had them. But this was something that caused Danny to be fired. The prosecutors, though, didn't see it that way. They saw this as an opportunity, and they called Danny in for an interview. And here's how that interview went. You see, because we went to trial, Danny was a witness, and he took the stand. And so this is sworn testimony at trial, an unheard of development in these cases, to be able to see what the prosecutors did to try to build their case. So we asked him, okay, and the government told you, you can sign on the dotted line here, or you can face a potential obstruction of justice charge with a 20-year max prison sentence. Those are the 2 choices they gave to Danny for destroying those 2 documents. Answer, that is correct. All you have to do is testify against the company and against Howard Root, not truthfully, but against. Those are the choices that were given to you, right? That was the agreement. Okay, pretty easy choice, wasn't it, Mr. McGiff? Yes, it was. Now put yourself in that position. You're a guy who's got no money, never gone through a criminal thing before, fired by your company because you did something wrong, and the prosecutor says you have 2 choices. Sign what we tell you to sign, or face a prosecution on a felony. Raise your hand if you would stand up to prosecutors in that case. 1. That's it. Well, Danny didn't. He signed a guilty plea that the corporation had engaged in misbranding, and that was what they were going to take and put me in prison over. Then they took that and they went to other former employees, because former employees are where they can start and they can build their case. Deborah Schmaltz was our VP of Regulatory. She was called in for an interview, and this is her comments given to another employee of how that interview went. I was given a half glass of water and no food. I was interrogated for 6 hours. A couple times during the process, I requested to seek counsel from my attorney, and the prosecutor got mad each time I made the request. Then they started bringing our current employees in. Carrie Powers was my VP of Marketing. Here's her cross-examination sworn testimony on trial of how her interview by the prosecutors went. Mr. Paulson, the prosecutor, got extremely upset and said that if I did not start cooperating, he would recommend that I would lose my career and would never work in healthcare ever again. Now, how can prosecutors do that? Well, it's very easy. 1 word. It's called exclusion. Because if anyone in healthcare has been determined to commit fraud, the HHS will exclude you from working with any hospital that takes a federally funded patient, Medicare, which is every hospital in America. So Carrie, whose only job before Vascular Solutions was as a nurse, would be blocked from working in healthcare, her career destroyed, if she didn't, quote, cooperate with the prosecutors and tell them exactly what they wanted to hear. Then they fired up the grand jury, and Glenn Holden was our sales rep from Connecticut, who was unfortunately the first one to get pulled in front of the grand jury. Here's how his grand jury testimony went. Question, so is the answer to my question a no then? You weren't trying to increase business? Answer, no. I would say that I'm trying to help the patient population. That's first and foremost, that's my job. And that's exactly how we train our sales reps. Start clinically, sales happen. Don't focus on the sale until you establish the clinical utility of our products. Here's what an assistant U.S. attorney said about Glenn's testimony. Glenn is a poor effer, using the actual word, who needs to return to San Antonio on bended knee to fix his testimony. Glenn didn't because he told the truth, and for that, he was indicted on felony perjury charges, scheduled to stand trial 1 month after my trial, and could have gone to prison for over 10 years. They even did a unique thing in my case. They actually took the grand jury on the road. Now, they didn't take the grand jurors on the road. They left them in San Antonio, but they decided there was an easier way to get grand jury testimony. Because Dr. Pepper is one of our customers up in Bellevue, Washington, they didn't want to drag him down there, so they said, Dr. Pepper, you've got a choice. You can come to San Antonio and get testify in front of the grand jury, or we'll come there, and we'll take testimony from you there. And here's how he talked about it in his grand jury, not really grand jury, transcript. They actually took this in Bellevue, Washington. Question, and you've agreed very graciously to give your statement under oath here today. That's correct. I understand this is grand jury testimony, is that correct? Well, we're doing a grand jury investigation, but this isn't grand jury testimony. Okay. This is just testimony outside of the grand jury because the grand jury's in San Antonio, Texas, and you're all the way over here in Bellevue, so we'll try to do it this way. Well, now, why did they do that? Well, they did it because the grand jury wouldn't have to hear the evidence. And if there was something good, he said, good in my sense, the grand jury wouldn't consider it. If there was something bad, they could give that to the grand jury. All they did was they took the transcript, put it on the grand jury table, and walked out of the room. They never even saw what Dr. Pepper said, which was all good about our product. Now, I saw this and I said, can they do this? Can prosecutors take grand jury transcripts on the road without the grand jury? My lawyer said, well, there's nothing that says they can, and there's nothing that says they can't. And so they did. If you want to see the prosecutorial power, you've got to really talk to witnesses who are too scared to talk to you after they get out of the grand jury or the investigation process. And a lot of this stuff I didn't find out about until after the case was done. Beth Matthews was another one of our regional managers, and here's an email that she sent to me a day after the verdict came in. The prosecutor said, if you do not deliver us with the answers we want to hear today, it should be made known that we have the power to withhold rights and privileges provided to your natural-born son. Now let's put this in perspective. This is a criminal investigation about a product that had been approved by the FDA 8 separate times, about the words spoken by 2 sales reps, about a use that a doctor legally could do, was infrequently done, and never harmed a single patient. And they're threatening the children of my employees to get the testimony they want to try to put me in prison. Well, why don't we settle? Why don't we just get out of this? Everyone just pays the money and walks away. That's the way it used to be, and you can't do that anymore. You see, their settlement offer pre-indictment was that we had to pay a 7-figure fine. They love to talk in 7 figures, 6 figures. Nobody talks like that except people who don't deal with that. $10 million, fine, I will pay you. It cost me $25 million to fight. I would pay you $10 million to go away every day to get out of this problem. But there's more. We had to agree to remediation, which means an integrity agreement, which means a corporate monitor. Okay, we can deal with that. To avoid an indictment, I will do that as well. But wait, there's more. Vascular Solutions must agree to terminate Howard Root, Glenn Holden, and Beth Matthews, and discipline Shane Carlson, Kerry Powers, and Susan Christian. Throw multiple employees under the bus. That's where we have a little bit of a problem. On top of that, I had to plead guilty to misdemeanor misbranding, which would end my medical device career, and me confess to being a criminal for something I didn't do. And then they said, in a perfect affront to due process, you can go over our heads to our superiors, but your pleas would fall on deaf ears and would be a total waste of time, as the push to charge Howard is coming from above. So don't even bother. This is it, best and final answer. And we said no. Well, I thought, there's got to be someone who can get involved in this, because this has gone way off the rails. There's just no way this should be happening in America today. And I had some friends from back when I was a lawyer. In fact, in 1986, I threw a party. My roommate at the time is now the U.S. Attorney in Minnesota, Greg Brooker, and here's a picture of Greg on the dance floor at that party. My coworker at the time, I worked with her for 5 years, is now U.S. Senator Amy Klobuchar, and here's a picture of Amy in the corner at that party. And just so you know that I'm not picking on them by showing pictures of their dance moves in the 80 fashion sense, here's future CEO Howard Root at my own party. So I know I'm not going to go and talk to Greg, because that would be inappropriate, because you can't get friendly with that just wouldn't be right. But we could appeal to Maine Justice. And by this time I had hired King and Spaulding out of DC, and they did the appeal for us. I said, let's get a short letter sent in to Maine Justice to see if someone will get involved. And in lawyer speak, a short letter is 20 pages, detailed all the way through, and we sent that in. It laid out our entire case and why they should not be prosecuting us. And then we did what you always do. You do a courtesy call to the prosecutors, letting them know that you're going to send it in. And the prosecutor said something very interesting to our lawyers in that courtesy call that was repeated in the letter sent in to Maine Justice. The prosecutor admonished that we would not look positively on the submission of this appeal letter and that you should think about that. He concluded by warning that we did something for you with the understanding that you wouldn't do this. Send the letter if you want, but if you do, it will be a mistake. Threatening us for having the right or the gall to appeal their decision to Maine Justice. Well, we thought that was great because we thought someone's going to get involved. We had a 1-hour meeting with Maine Justice. I did not attend, the lawyers did. And after that, we followed up trying to get an answer, and the response from Maine Justice came from Bud Paulison, our San Antonio prosecutor, where he said, I understand that defense lawyers reached out to John Olin. I have been authorized by Consumer Protection Division to be the point of contact on this matter. Kicking it back to San Antonio, they would never get involved. Well, I thought I can appeal to my friend, Senator Amy Klobuchar, so I sent her chief of staff an email where I said, over the last 4 years, Vascular Solutions has been complying with the Department of Justice investigation. Thank you for whatever assistance Senator Klobuchar can provide. The same day, just an hour or two later, I got the response from the chief of staff saying, it has been a long-standing rule of the Senate that senators cannot get involved in ongoing investigations at the Department of Justice, but thank you for letting us know, which is 100% positively false. There is no such rule. How do I know? My lawyers at King and Spaulding used to work in the Department of Justice, and they got calls from senators all the time on little matters, other matters. The deal with this is no politician is going to get involved with an indicted defendant on a criminal matter because it could be the end of their political career. So this was a way for Amy to say, I can't, rather than I won't. Well, I didn't take no for an answer, so a year later, I sent the next email into her chief of staff where I said, since Senator Klobuchar is on the Senate Judiciary Committee and a former prosecutor herself, I thought she should be informed about what is going on within the Department of Justice that affects our Minnesota medical device community. The response I got an hour later from that chief of staff, thanks for reaching out. I'll be sure to pass this along. Have a great day. Now I know the chief of staff is young. She never had any experience in the criminal justice. She meant nothing by that. But the great day that I was going to have was to get up in the morning, go out and get the morning newspaper, the only newspaper I've ever known in my entire life, the Minneapolis Star-Tribune, and look at the front page, not of the business section, of the overall paper and see my picture with the words MedTech CEO accused of conspiracy, and it only got worse from there, and know that everyone who sees you in your hometown is going to think Howard Root, felon, until you can get your name exonerated. Well, why are these newspaper stories so bad? Well, it's obvious. DOJ loves to bloody up the defendants just upon an indictment. Not a conviction, just an indictment. Here's the press release they did in my case. Assistant AG Joyce Branda said, this was a deceptive sales campaign led by the CEO of a public company, even though I was the one who instructed our sales reps to go beyond the law to comply with even the non-binding FDA guidance. Assistant Attorney General Stuart Dellery said Vascular Solutions was a company that put profits over patient safety for a product that made up 0.1% of our sales and never harmed a single patient. And U.S. Attorney Robert Pittman said, Vascular Solutions knowingly promoted medical devices for unapproved uses when we had always all the approvals we needed under the law, and we were just talking about an FDA guidance. But these three people never met me, didn't know my case, and were just signing their name to words drafted from some publicity person to bloody me up. And then at the very end, they always add the last qualifying sentence, an indictment is merely an allegation, and every defendant is presumed innocent until proven guilty beyond a reasonable doubt, which never gets picked up in the paper. But when you get indicted, you're thinking there is a good side to this because now there's going to be a judge involved. I don't have to go to Maine Justice. I can go to the judge who's going to try this case, and we can get this case dismissed for prosecutorial misconduct because this is really bad stuff. And the King and Spaulding lawyers said this is awful, awful conduct. So we put it together and filed a motion to dismiss the indictment for prosecutorial misconduct. In it, we talked about what they did. We said, when witnesses contradicted the prosecution theory, the civil division attorney went so far as to recite lengthy grand jury excerpts and his own version of the facts, and to demand that the witnesses recant their prior testimony. Now, taking grand jury transcripts and reading it to another witness and say your testimony has to correspond to that, that's about as bad as it gets in obstruction of justice in my world. This is something that is just black letter law you do not do. And then we followed it up with a little sugar on the top or a little spicing. The government characterized a group of witnesses' testimony as the same line of shit, given by others who refused to admit the obvious truth and warned that the witnesses must fix their testimony or face criminal prosecution. Now, between those two paragraphs, I thought any judge in America would be incensed at what was going on. This is not the way prosecutors are supposed to act or the way they're supposed to speak. We got our ruling 3 months later, and the ruling was exactly word for word, letter for letter, what the prosecutors gave the judge to sign. In it, the judge said, "The court finds that this matter does not require a hearing, doesn't even want to take any evidence, because the record does not demonstrate that the attorneys for the government forced any witness to lie or that they misshaped the testimony of any witness." Why? Well, the prosecutors thought the witnesses were lying when they told their original story, so getting them to tell what the prosecutors wanted to say, that was telling the truth, not a lie. And then the judge added at the end, "Even if this court found the defendant's allegations of misconduct to be true and conclusively proven, the remedy would not be dismissal of the indictment." So the judge is not going to get involved to dismiss an indictment because of prosecutorial misconduct. The cases where a judge has done that is exceedingly rare across America. So we had 15 months from the date of the indictment to keep our public company together and get to the trial, and we did that. We pushed to make sure that we got that trial date specified. We got there. It was in February of 2016, and I go down there, and I'm ready for the opening statement. I'm sitting in my chair. I'm grabbing the side, and I look at Bud Paulison, who's been on me for over the last 5 years, getting ready to give his opening statement, and he says this: "The defendants sold a medical device that they knew, based on their own testing, could cause deep vein thrombosis." Well, I see where he's going. He's trying to make it look like it's a dangerous device, could cause, it's going to slide over, but they're saying that this is going to be dangerous. He continued, "And we want to be very clear about something. We have no evidence, and we'll show you no evidence," you're ready for it, you're gripping the side of the chair, "that anybody died from using this device." Well, that's not so bad. That's actually pretty good. And let's say it again, let the jury hear. It got worse from there. They called only one clinician who had ever used this product, Dr. Duncan Belcher, a Yale-trained interventional radiologist. And on his cross-examination, Dr. Belcher said, "I've used Veralaze for 11 years with nothing but good outcomes. Veralaze is safe and effective, and deep vein thrombosis risk that Bud was talking about in the opening is completely hypothetical and never seen." All the clinical risk was gone. It got worse. They called only one FDA witness, Neil Ogden, who's the branch chief over the varicose vein area. On cross-examination, he was so ready to go off, he volunteered answers. And he said, if the company wanted to say perforator veins, they could put it in their indication for use. Our lawyer asked him, "And that would be a specific indication, correct?" "Yes." "And FDA, that's under FDA's guidance, correct?" "Yes." "It's FDA's guidance that says you should list specific indications that you want, correct?" "Yes." "Okay. And the guidance is not the law, correct?" Answer, correct. Now that's the moment you want to drop the mic and walk out of the courtroom, because their witness has just admitted that you're being prosecuted for the crime of 2 rogue sales reps violating a non-binding FDA guidance document. There's no judge in America that would allow you to get convicted for that, but you got to continue to go on. And you're sitting there and you're wondering, how can this be happening? I mean, how did these prosecutors get this case so wrong? I mean, there's just no way this is going to go out well for them. Well, the beauty of my case, they called their special agent investigator to the stand as the last witness. And we got to ask him on cross-examination any question we wanted to do. Now this guy, this is an actual picture. This is what he did in the courtroom. He had the little stubble and he's doing this a lot, and he had bowling shoes on and he was kind of mumbling to himself. He was so wired to get me taken down that you could tell this guy was on me, and this is what he wanted to have happen. And these special agents actually carry guns because guys like me are so darn dangerous, you need weapons to take me down. But here's how the Q&A went on cross-examination. Question: you didn't think it was important to actually put in front of the witness the words of what the FDA has actually cleared and walk through the understanding? Answer: when I'm interviewing these people, I'm not there to make the defense's arguments. Agent Scavdis, you're a federal law enforcement officer, isn't that right? I am. Your job is to find the truth and the whole truth, is it not? I'm a fact finder. Now this hit me when I was sitting in a courtroom very, very odd for a lot of reasons. First, he's calling me the defense when he's investigating what went on. I wasn't a defendant. I wasn't indicted at this time. He was investigating what was going on. So why is he calling me the defense's arguments? And why will he not even admit that his job is to find the truth as a law enforcement officer? He's not the prosecutor. But instead of all that, he's saying, I know who the defendant is, and my job is to find the facts. And so the question is, what facts was he trying to find? So we got to ask him that, and he said, that's one of the first things that we look for in my squad, is we're a small squad, and the cases that we want to invest our time and resources in are cases in which the conduct is top-down and wide-ranging. I realized they weren't looking to investigate a crime, they were looking to find a criminal. They wanted to find a CEO of a medical device company with a nationwide sales force that they could go after on off-label promotion. They had lost 2 cases already in the last year, and Vascular Solutions was the one they targeted to be the one where they could put a CEO behind bars for the heinous crime of a sales rep saying the wrong word. Well, let's look at the flip side. What facts did he ignore? And he ignored facts of a crime that occurred in my case. We asked him. Another thing you did not write down was that Mr. Finley, one of the prosecutors, actually read excerpts of grand jury transcripts, testimony, from other witnesses to Ms. Matthews. Answer, that's correct. Now, your understanding is that these grand jury transcripts are supposed to be secret, isn't that right? That's correct. And then you talked about recommending to Vascular Solutions that she be fired, right? If she didn't fix her testimony? That's correct. Now that again, to me, that's a felony. And not only did George Skavdis not investigate that, he didn't even write it down because it wasn't the facts that he wanted to find. The whole clinical thing was gone. They had no risk, they had no argument that we had any danger to patients with this. So on the emotional appeal of this trial, the prosecutors fell back to the one thing that they always do in this case. And Frank knows it, I think a lot of people know it. It's money. Opening statement, when you hear the evidence, you'll know it's about money. Closing statement, this is a for-profit corporation. This is about earning money. Closing rebuttal, why? You know why, for money. And they carried that over when they were doing their examination of my sales reps. They have a money fixation within the prosecutorial office in San Antonio. Christina Playton was one of the other assistant U.S. attorneys on this case, and she was examining, calling as a witness, one of my sales reps. Here's how that exchange went. Vascular Solutions is not a charity. No. It's a for-profit corporation. That's correct. Vascular Solutions, the defendant, doesn't pay you $191,000 a year to help your friends out, does it? No. And then she brought the doctors into it. If your folks went out and were saying to the doc, there is this thing you can do and it'll put a nice car in your garage, implying that we're just doing this for the money and trying to get the doc to do it for money and everyone's in it just for the money. Well, I thought that was kind of strange that she would go that way because there was no testimony about that. So after the case, I did a little investigation, just some internet research on who Christina Playton is. And I found out that she's married in San Antonio. Her husband is Dr. Michael Albrecht, who's a surgeon in private practice, or I should say for-profit private practice. And then I looked at what kind of house they have down in San Antonio. They just bought it a couple years ago. It looks like a nice 4-bedroom one with a 3-car garage for the 2 of them. I don't know what cars, but probably a nice car in their 3-car garage. And through the magic of Google Maps, I know that Dr. Michael Albrecht probably makes a little more than $191,000 a year. And yet she's claiming that I have that profit motive. The conclusion of the prosecutor's case went this way. Here's the transcript. The judge said, the government having rested, at this time, the defendants will have the opportunity to call witnesses. First, I will call Vascular Solutions. Mr. Posey, our lawyer for the company. Thank you, Your Honor. Vascular Solutions rests, Your Honor. All right, the defendant Root, Mr. Lundquist, our lawyer, my lawyer, as does Mr. Root. Thank you. The court, all right, a nice surprise. We're all going home early. Juror, wow. That's the transcript. I've read a lot of transcripts. I've never seen a juror quoted in a transcript. I didn't know which one it was, but I was pretty encouraged that he wanted to go home right along with me. Now, we didn't call any witnesses because we didn't have to, but that's not meaning that we didn't have any witnesses to call. And I want to give you just one of the witnesses that we were planning to call at the trial. This is a defense witness that we did not call because we did not need to. His name is Randolph Copeland. And he was the FDA reviewer on that 9th application that got rejected at the FDA, claiming that that one, for some reason, needed clinical data. And we brought him down to San Antonio, and here's a picture of him signing an affidavit on our behalf with our lawyer in the break room of the hotel where we were staying. And the affidavit said this: Mr. Copeland was hired at FDA just 1 month before picking up our perforator FDA application. His immediate prior job was at McDonald's. Yeah. He was the branch manager, he was the night manager at the local McDonald's. He had no medical device experience. He had a college degree with some physics and laser background, but nothing even related to our area. In spite of that, he told Agent Skavdis that the FDA laser expert who he consulted, because Randolph knew that he wasn't that experienced in this area, so he consulted the expert, and the expert strongly believed that clinical data should not be required, but the laser expert was overruled by an FDA manager with no laser experience who wanted to see clinical data to support virtually every filing. Now that's relevant information, because that's saying we didn't have to file anything, we always had all the approvals. So we sent, what we should do is we sent a Brady request asking for any information that the prosecutors had about Randolph Copeland, because they never even told us about this guy. We found him independently of anything the prosecutors said. The response came back this: in response to your letter requesting Brady material related to Randolph Copeland, we have been unable to find any. Didn't tell me how hard they looked. We did not conduct any interview with Mr. Copeland, using the scare quotes around the word interview, which you know they're going to explain it in the next sentence. Agent Skavdis met with him briefly in November 2014 to inquire about whether he would be willing to participate in an interview. Based on that meeting, it seemed that Mr. Copeland did not have any relevant knowledge. Well, two things there. Relevant to whom? Probably not relevant to putting me behind bars, but very relevant to me being an exonerated defendant. But more importantly is, if you meet with someone, if you ask them questions and they give you answers, and from that you make the determination that that witness does not have any relevant knowledge, how is that not an interview? They didn't write it down so they wouldn't have to use it to give to us in order for us to have that exonerating evidence. The jury came back after a short deliberation exactly as we knew they would, not guilty on all counts. Not only that, one juror emailed me 1 hour after the verdict. This is alternate juror number 1. She sat through the entire trial but wasn't able to deliberate because none of the real jurors dropped out. But she emailed me 1 hour after finding my email and emailed it to me and said this: I turned 52 years old yesterday, and in all my life I have never feared the government. As a law-abiding, tax-contributing citizen, one should not have to fear our federal government. Unfortunately, I will never feel that way again. What the federal government did to you, your company, and your employees is nothing short of criminal. Now think about it. Prosecutors pick the case, they pick the defendant, they pick the court, they pick the timing, they pick the evidence, they pick almost the judge, they can pick everything. We didn't call a single witness to testify. All we did was cross-examine their witnesses and go with the closing argument, and the jury wants me to go free and the prosecutors go to prison. That's how messed up these cases can become. My reaction, as you can tell, I had a few strong thoughts after I walked out of the courtroom. I finally got to write the press release and issue it. I had about 100 redrafts of this, and I started off with a very clear sentence. The company and I are vindicated by today's verdict, but outraged by the obscene legal process we were forced to endure. And then I took every one of those statements they made in the indictment and said I want a retraction and a correction, which of course never came. And then I thought we need to get another case dismissed because Glenn Holden's case for perjury is still pending. So I said this: it should now be obvious that Glenn Holden's indictment was merely a malicious retribution by misguided prosecutors. And then I ended with the best press release I've ever written in my entire career, or best sentence I've ever written in a press release. And after his indictment is dismissed, if the U.S. Attorney in San Antonio still wants to prosecute someone for obstruction of justice in this case, in my opinion, he wouldn't even have to leave his own office to find the most suitable person to indict. And of all the things I said about the prosecutors here, and that's the worst one, the one thing they objected to the most, and this will tell you a lot about the culture, the one that they were shocked about, I heard secondhand from people down, our local council down in San Antonio. They were shocked, amazed, and distraught that I put their names in the press release. Because if you lose, anonymity is your protection. Well, there are two types of punishment that defendants get when they go through these cases. The first one that every defendant gets is by the process, and please do not underestimate this. We had to hire 121 lawyers at 14 law firms to defend ourselves through this process. Why? Because they brought over 50 employees and customers in to be interviewed by the prosecutors, and it's in our best interest to pay for the lawyers so that those people have a defense that can actually defend themselves. That means multiple lawyers for everyone, plus local counsel down in San Antonio, which I had no connection to, but that's where they wanted to prosecute me. That means we spent $25 million over 5 years in legal expenses. But that's just the process. The worst thing would be a conviction. And that's when the judge would come in. And Royce Lamberth from DC does his winters down in San Antonio. He was actually the judge that took over for Beery for our trial. If I had been convicted, Judge Lamberth would have given the sentence, and he is, quite honestly, a hanging judge. He sentences them hard. A lawyer told me that if I had been convicted of the most likely charge, I would have been sentenced to over 36 months in prison. It would have been a felony. 85% of that time has to be served behind bars. I would be in prison today. The company, if the company was convicted of anything, it would have been excluded from selling any of our medical devices to any U.S. hospital. The company would have been shut down, the devices sold off in a huge garage sale in Minnesota, and all the employees would have lost their job. Well, I wasn't convicted, so I asked the obvious question to that same lawyer who knew Judge Lamberth, what were the odds of me getting convicted? I asked him this: how many acquittals has Judge Lamberth had in the last 10 years? Do you want to guess? Zero. I'm the first one to walk out a completely free and innocent man. 10 years. I found out that information after the verdict came back, some things you like to hear after the results are in. There is a third type of punishment that I want to point out to you, and it's not really relevant to you, but it's relevant to this whole culture. The third type of punishment is really punishment by your own lawyer. The criminal defense bar is a very unique thing. I went through 2 lawyers before I arrived at King & Spaulding who did a phenomenal job for me, but my first 2 were disasters. The first lawyer I had, after I said I wanted a plan, sent back an email with this: for a host of reasons, I think it appropriate to move up the timing of the transfer of the corporate criminal representation. In other words, he wanted to quit. He wasn't going to be my counsel anymore after he'd been involved with this for over 2 years. He just wanted out because I had the gall to ask him for a plan of how we're going to defend ourselves. So I went to a second defense counsel and brought him in, and he goes to my board and tells my board this: if Howard pleads guilty, I think we should be able to keep him off with no prison time, but we'll have to fight hard to keep him from getting banned from working in the healthcare industry. The first lawyer had no counsel in him. The second lawyer had no defense in him. And worse yet was the counsel that we hired for our employees, because we have to pay the bills, but they can do whatever they want. And this is how that counsel reported back to us after going down to San Antonio. We know it went well in San Antonio. Our witnesses were prepared, not intimidated, and gave us a good debriefing afterward. We developed a good relationship with the 2 prosecutors assigned to the case. That last sentence is the important one. The criminal defense bar generally wants to make nice with the prosecutors. They're generally former prosecutors. Oftentimes they still have that demeanor, and they're not believing their client as much as they should. So there's a problem here on both sides, on the prosecution side and the defense counsel side, in order to get adequate representation for a just verdict. My case was not a lightning strike. This is not a 1 in a million type situation. Acclarent is a smaller medical device company than Vascular Solutions, a private company. Its CEO was indicted and convicted of a strict liability crime of his sales reps saying a wrong word. He was convicted in July of 2016, and he's still awaiting sentencing, 2 years later almost, because the judge doesn't know how to sentence a strict liability crime. Warner Chilcott, a drug company here in Pennsylvania, I think, had its CEO indicted and found not guilty after an 8-week trial, going through the punishment of the process before being exonerated by the jury. Spectranetics, a company out of Colorado, has his CEO indicted and convicted, not of the underlying offense, but the process crime, because he wasn't advised very well, and he gave a statement to the investigators right away, and they got him for perjury on that statement. 50% of public medical device companies, by my count, have at least one investigation, all of those criminal. FedEx, outside of medical devices, was indicted, and then all charges were dropped in the first week of trial. They were charged with being a drug runner for picking up packages from internet pharmacies. The judge, after the charges were dropped by the prosecution, ruled that FedEx was factually innocent, but no investigation's been done on that case. It would be safe to say that every business in America today can be indicted on multiple felonies every single day. And it's even worse than that, because every CEO is a criminal in America today. I will give you the jury instructions that would have put me behind bars. Here's what they told the jury. The United States is not required to prove that defendant Root knew about or intended to commit the misbranding violations. Strict liability. Knowledge and intent is not required to be convicted of a crime in America. Instead, you must find beyond a reasonable doubt that by reason of his position in the corporation, he had the responsibility and authority either to prevent or promptly correct the violation, and he failed to do so. Now, I would swear under oath that I, as a CEO, had the responsibility and authority to prevent and correct every violation in my organization. The buck stops here. So the only question is, did a salesperson say a wrong word? If they did, I go to prison. In spite of me not knowing about it, in spite of me telling them not to do it, in spite of me not having any inkling of what was going on, I would go to prison. And I had 100 sales reps. And you don't know sales reps, think teenagers, same motivation. So think 100 teenagers, and if one of them says the wrong word, you go to prison for 3 years, you're not going to want that job. So my decision after it was all over was very simple. I did it in a press release, and I said this: while I still love Vascular Solutions 20 years after I started the company, I'm not willing to assume much longer the personal risk associated with being the CEO of a public medical device company, and I sold it to Teleflex, which is located here in the Philadelphia area, late a year ago, and walked away. I retired that day and will never develop another medical device in my life. My perspective, overall perspective, when it's all done, is that I am one of the few and most fortunate criminal defendants in America. And I see Frank nodding his head because that's another guy just like me. I had the $25 million. I had a board of directors that kept me in the chair. I had employees that stood with me at personal risk. I had a family that stood behind me, and I was a lawyer, so I could step in and manage my legal team to get the right defense in order to be exonerated. And what happens to those people who don't have those advantages? So I wrote an op-ed in the Minneapolis paper after it was all over, and I said this: I know that others have suffered far worse at the hands of prosecutors in a culture that accepts and encourages unjust tactics. I also know that I'm lucky to be backed by a financially successful company that provided me with the money I needed to fight and win. And then the question is, what happens to those who are less fortunate? And since I started talking out about this, about once a month I get an email from someone I don't know. And I look at the subject line and I know it's going to be a bad day because I get something like this. Here's an email I got last September. Subject: not sure where to turn. And your heart goes down. And you read: my best friend and employer is in the middle of the same type of fight. Everything he's ever worked for is in jeopardy. I can promise you that he has done nothing wrong. My contact information is below. And so I call him back. I call him up and I talk to him. And I have to ask him pretty much the first question, which is just a sickening question in America. I have to ask him, how much money do you have? And they say, I got $100,000. And I say, plead guilty. Because if you fight and run out of money, it will be worse on you than if you give up right at the start. And that is not the way the American justice system is supposed to be. If you've got $5 million, I can help you. If you got $1 million, maybe if the charges are limited and we got the right prosecutor, you can go away. But if you're less than $1 million to spend on your own defense, you are going to be convicted in America today. That means my case in retirement has now become my cause. And I wrote this book, Cardiac Arrest, which I joked with my co-author, Steve Saltarelli, who's a young lawyer who worked on the case with me. It's an instant cult classic. And the cult is very small. But it's actually, I checked on, it's on Amazon, it's on Kindle, it's an Audible book version. And I checked on Amazon, it's actually selling better than Amy Klobuchar's autobiography. It's got legs. But I wrote this book because a lot of people going through this, and Frank, again, I think would be in agreement, don't know that other people are going through it. And just understanding that it's not you, it's them, is such an important step to keeping it together to be able to fight the charges. So this, for business people getting attacked or getting investigated, I think is a useful resource. But that's just the start of my cause. The other part of my cause is try to make change. And I've got the money, so I went out to DC and I actually got some people interested. Senator Grassley sent a letter to Deputy AG Sally Yates before she left about my case and asked for her to talk about what was going on in this case and the wrongdoing of government attorneys. And he got a response back about 20 days after it was supposed to come back from Peter Kadzik, and in it, Peter Kadzik gave the standard party line. The defendants were provided an opportunity before the district court. All the facts that they claimed supported their allegations. The district court considered those facts carefully, and an opinion dated November 16th, the district court addressed each of the allegations, rejected each one as unfounded, and denied the defendant's motion. That's the one where the judge said, no hearing, no evidence, and even if you prove it, I'm not going to dismiss the indictment. That's what DOJ is standing behind in order to say there was no misconduct in my case. Well, we didn't take that as an answer, so our lawyers, my lawyers now, at King & Spaulding sent a request into OPR for an investigation of misconduct. They said this: as former federal prosecutors, we do not make this request lightly, but based on the foregoing, a full and complete investigation by your offices is warranted. The response came 1 year later from Jeffrey Ragsdale in the OPR, which is part of DOJ investigating DOJ misconduct, and he said, just as the court found that government counsel did not commit professional misconduct, OPR did not adduce evidence supporting a contrary conclusion. OPR has thus closed its inquiry, hiding behind the same problem. You see, they're not going to investigate themselves. That's just never, ever going to happen. In fact, they don't even want to talk about it. See, I get called and asked to go to conferences, and I like to take those because I got nothing else to do and I'm retired, right? So two of them I got asked to do. One was, I was really excited about this. It's the 27th Annual National Institute of Healthcare Fraud, and the other one was the Life Sciences and Healthcare Quattrone Summit in New York City. That first one, the 27th annual, they pick a case every year, they do a deep dive, and they find out from the prosecutors and the defense what happened, and they thought this will be beautiful because we never get one where the defense wins. And plus, Howard, you can do the keynote. I said, that's fine, but the prosecutors aren't going to show up. Sure enough, they didn't show up. But worse than that, I couldn't do the keynote at that one or at this other one because federal prosecutors needed to be in attendance at these conferences to make them worthwhile. They can't have the conference without participation from DOJ. And when they said that they had invited me, that invitation had to be revoked. According to the one who called me, he got a statement from the DOJ, called him and said, someone from DOJ, to the course director for that 27th annual conference, if Howard Root is on the agenda, no one from DOJ will participate in your conference. The other one, emailed to me from the course coordinator, I would love to use you, but I'm afraid that government speakers will not participate. Well, this pissed me off. So I went back to my friend, Senator Grassley, and I said, why don't you add this? And so last March, they sent another letter, and we got Senator Lee from Utah on it, to Deputy AG Rod Rosenstein, who's got enough things to worry about. But it says this: taken together, these reports suggest a pattern of threatened and actual retribution against former defendants and witnesses born out of the department's disappointment with the outcome of a particular case. Please respond no later than April 5th. And of course, we haven't heard anything, but I'm going to stay on this case. Well, why are they doing this? Well, look at their own words. Look at what the culture is within the Department of Justice. Every year they do a press release, they talk about money. They say $4.7 billion in false claims settlement in 2016, $2.5 billion from healthcare. Relators filed 13.5 cases, and healthcare returned $6.10 for each dollar invested. They calculate a return on investment on prosecuting people like me. On the individual basis, they give out awards every year at the Department of Justice. It's a 376 employee ceremony with the Attorney General rewards, a 23-page press release which calls it as a rare opportunity to honor the efforts. Do you want to guess how many awards are for declining to prosecute a criminal target? 0. It's never happened. If you reward only one behavior, you will get that behavior. That is the culture in the Department of Justice. How do we change this? This is the big problem. It's not easy. But I'm firmly convinced that it needs to be an unwilling cultural change, because I don't think prosecutors by themselves are going to admit they have a problem, much less say that they've got to fix it. And how do you get an unwilling cultural change? Well, it starts from the top. Instead of doing the Yates memo, do Robert H. Jackson's speech from 1940, where he said, and it's a short speech, but I'm just going to give you the last sentence: the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. And humility is the one part we have to introduce into the culture of U.S. prosecutors. Second, get a second opinion before you make an indictment. We talk about false convictions. False indictments are almost as bad. For corporations, it can destroy them. They never get the chance to go to trial. So before they're going to indict someone, make sure they understand that someone else has looked at it to see that it's justified. Then eliminate these ludicrous public statements by prosecutors until after the trial, until after something's been proven. Do not reward those same prosecutors for victories. Reward them for justice, and make it equally about getting the right result and exonerating a defendant as it is about prosecuting. One or two of those within the Department of Justice would instantaneously send a ripple through the culture that maybe we're doing something wrong. And finally, conduct those DOJ misconduct investigations outside of DOJ. My compliance department would never report to the head of sales. The head of compliance within DOJ should not report to the head of DOJ. So I thank you for your attention. I know I go a little bit long and I get a little wound up, but thank you for allowing me to speak today.
Thank you, Howard. So we have about a 10-minute, we'll call it, break, but the good news is you can pick up a lunch outside and bring it back in, and in 10 minutes, Paul Heaton will lead us into a conversation about what we can do to restructure public defense and access to defense. Thanks very much.